As you know, in November 2019, the AG served a subpoena on First Hawaiian Bank for Kahea's financial records. In its opposition to this bill, the AG makes three arguments that we address here. First, the AG argued that the subpoena is their subpoena powers are necessary to investigate some quote-unquote illegal activity consisting primarily in Hawaiian kupuna cultural practitioners blocking a road, and in the AG's view, such illegal activity is never protected by the Constitution, and even if it is, those people can hire their own attorneys and file a lawsuit. So, I mean, well, first of all, like, just being arrested when being engaged in civil disobedience isn't per se illegal. Like, you have, like, the whole process, the whole criminal prosecution process, and there's the lesser of two evils offenses, and so it's not, so it's kind of putting the back to the front to just up front say that's illegal. But we also need to examine exactly what the AG is investigating. Quote-unquote illegal activity in blocking a road hugely understate what the Kia'i Mauna movement is, and also overstates the role of Kahea the role that Kahea plays in that. I mean, the movement is, amongst other things, an organization of thousands of people led by Hawaiians and Hawaiian cultural practitioners to communicate, shelter, bookkeep, shop, order, plan, clothe, feed, caretake, transport, clean, educate, and inspire multitudes across Hawaii and internationally. If that's supporting illegal activities, there's a lot of people doing that. So our organizing work means empowering communities to make decisions, to take action towards protecting Hawaii ecosystems and cultural resources. Nonprofits engaged in community organizing, we don't buy food and then tell people they can't have any if they plan on getting arrested. And so I'm pointing to the ways that community organizing and direct action, including civil disobedience, are inextricable, and especially for Hawaiian cultural practitioners exercising constitutional rights in defense of public trust lands that also have an unsettled legal status. I mean, there's still the Mauna Kea Access Road lawsuit that, well, they have a notice of intent to sue and a lawsuit coming. The kupuna did not stand in the road because they were getting free lunch, and Kahea did not condition lunch on civil disobedience. And so the line that AG is trying to draw against constitutional protections for civil disobedience is not the same line SB 42 cuts against the AG's retaliation against nonprofits. Like, buying a giant rice cooker is not an illegal activity, and if the AG wants to frame it that way, then it should get a warrant for our records instead of abusing its regulatory powers by issuing a subpoena. In any case, it seems impossible to justify the AG's categorical statement that exercising rights by nonviolent civil disobedience that are protected and granted under the Constitution is always inaccurate. We don't know what acts are a crime until someone is adjudicated guilty, and not every command of a law enforcement official is a lawful order. Second, the AG argues the bill restricts its ability to protect charitable assets by policing fraudulent charitable organizing. But no one, including the AG, said Kahea is committing fraud or embezzlement. The AG stated in court that we're being investigated because we developed the Aloha Aina Support Fund to support Kia'i Mauna direct action. And you don't even need a subpoena to investigate that because it's on our website. What is going on is that the AG is harassing and intimidating a nonprofit standing squarely on its mission because we disagree about the TMT. By its own language, SB appropriately protects nonprofits from investigations, quote, during a period of time when it is clear that they are exercising constitutional rights of nonviolent disobedience, and not as part of a criminal investigation. The AG's testimony does not even address that situation. Third, the AG contends SB 42 is unconstitutional because its investigations aren't a Hawaiian affair. The bill plainly implements an intent to protect Article 12, Section 7 traditional and customary rights, and that's what it says it does. But if this committee feels that argument has merit, it can easily amend the title to relating to nonviolent civil disobedience or relating to the Attorney General.
Civil disobedience is by definition illegal conduct, and there is no constitutional right to engage in it. The bill is also unnecessary because the subjects of investigations by the Attorney General are entitled to seek redress in the courts if they feel that their rights are being violated. Instead, what the bill does do is it unnecessarily restricts the Attorney General's ability to investigate potential illegal activity, and it could give the green light to violate the law without fear of enforcement.
I guess my, the intent of this measure was not to stop you from doing your job, which is important, if there are nonprofits that are in fact committing, if they're doing something wrong. But you're saying that this bill would stop you from doing that?
That's correct. The bill, the only exception that would allow an investigation is if it's preceded by an allegation of a criminal act supported by probable cause. Investigations oftentimes are how you develop probable cause. And in addition to that, there are civil and administrative investigations that are conducted in order to protect the public interest as well. So yes, to answer your question, yes.
Darren Akiona. Good afternoon. I testified earlier during Bill Eiler's confirmation earlier, and at that point I brought up the issue of why is the legislature staying silent on what's going up on Mauna Kea. And first of all, let me thank the committee and Senator English for bringing this legislation forward. I think it's much needed. I think this legislation came forward not because Kahea was subpoenaed, but there's been a history of action being taken by the Attorney General regarding Mauna Kea that should cause the legislature and people to take a look at what's going on. Kahea did not only the Attorney General did not only subpoena Kahea, it subpoenaed Hawaiian Airlines for all the mileage records donated to the Mauna. Now, I don't know how broad you can make a subpoena than that. But the idea that government making subpoenas this broad has one effect that it should have, which it has a chilling effect on everybody else. And to me, that is the action that the Attorney General has done. It has taken steps along the line of what has happened in Mauna Kea to send a message out to anybody else who's thinking about looking at it or supporting it or expressing an opinion that if you do, then we, the Attorney General of the State of Hawaii, may have a cause of action against you. And that's the dangerous precedent that the Attorney General has set. They might not, but hey, look, we subpoenaed Hawaiian Airlines, we subpoenaed Kahea. What's even more telling about what's going on this issue is not one person who was arrested that day has been convicted of anything. Nothing. It's in quote, an alleged crime. What's even more telling is after the incident took place, there became a question of who had jurisdiction up there to do the arrest. I stood in the hearing of the first 5 kupuna who were taken to trial in Hilo. And the testimony by the DLNR was telling because all they would say was it's a public road. When asked who gave them the instructions to arrest and who gave them instructions to stop, the testimony was, we got a call from Honolulu. We were told earlier that the Hawaii Police Department was in charge of this. So again, we're getting information, on this situation that what I'm here to express is I express the support and the continued conversation that needs to take place, because that's the only way people in this state going to have an idea of what really is going on the side of the administration, on the legislature, and of the people who's interacting up on Mauna Kea. I think that's extremely important right now. Dialogue is extremely important.
Chair, how are you? Members of the committee, thank you very much. My name is Samuel King II. I'm speaking in my individual capacity. I know I've been involved in this Mauna Kea debate, but in this particular instance, I personally had something to say. I think this bill is absolute insanity. I think that it is crazy to pass a law that legalizes anarchy. So fundamentally, what this bill is saying is we can go around doing whatever we want in civil disobedience, and we can finance it with whatever money we want, and the state doesn't have the right to look at what we're up to. As the AG pointed out, we already have a constitution in this country and in this state and laws that will protect Kahea. Kahea is in court, and they have many, many smart lawyers like Bianca. I know her from law school, so they know how to fight in court, and they've been doing it for a long time. So they do not need more protection that's special just for them. They go to court and defend themselves. But fundamentally, you cannot be having nonprofits run around spending their money on whatever they want that is illegal. As the AG pointed out, civil disobedience is by definition illegal. The only reason this bill has gotten a hearing, as far as I can tell, is because of the nature of the protest that is bringing all the people out to testify in favor of this. If this was anti-vaxxers and an anti-vax nonprofit blockading the Department of Health, nobody would care. No one would even be talking about this. And that's important because there's a distinction about what's in the eye of the beholder here. These protesters have been saying, oh, well, this is the Native Hawaiians this and the Native Hawaiian that. I've been hearing that all day long, involved in this debate. And when I come out as a Native Hawaiian and I speak in favor of TMT, all I get is told that I'm a fake Hawaiian. Now, that's a strange insult for someone to tell me that I'm a fake Hawaiian, because what it implies is that to be Hawaiian, you must have some sort of political belief, and have the right or the power to impose that belief upon my Native Hawaiian identity, which is offensive in the extreme. So the real interesting thing here is I have to drive home the point about the extent to which I disagree with the protests that have driven this bill to its existence, because without this kind of moral backing, this bill would obviously be nonsense. The protesters have based their argument on the fact that they're protecting traditional and Native Hawaiian customary practices, which are protected by the Constitution of the state of Hawaii. But the real point here is that they believe, at least a large chunk of them, that Mauna Kea is sacred. Mauna Kea is not sacred to Native Hawaiians. We are not required to believe that. And I know that because of the Ainoa. We destroyed the Kapu religion. We did it. Our chiefs. Queen Kahumanu decided that we were not going to have this process. This is what we learned.